Thank you. Gentleman from Kentucky is recognized for any questions he may have for the panel.
Thank you, Mr. Chairman. Ranking Member Nadler, are you aware of the November 26, 2012 letter from the Bureau of Alcohol, Tobacco, Firearms, and Explosives to the inventor of the stabilizing brace, Mr. Bosco?
No, I'm not.
Okay. On November 26, 2012, Mr. Bosco received correspondence from the ATF telling him that these were legal. And I'll just read 2 sentences from this letter, which I will submit for the record. I'll go ahead and ask unanimous consent.
Without objection.
They tell Mr. Bosco, you are asking if the addition of this sample buffer tube forearm brace would convert a firearm in a manner that would cause it to be classified as a rifle and thus a firearm regulated by the National Firearms Act. I'll skip some of this. Based on our evaluation, FTB, that's the Firearms Technology Branch of the Bureau of Alcohol, Tobacco, and Firearms and Explosives, FTB finds that the submitted forearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification of a pistol or other firearm. Mr. Bosco received this letter from the ATF, and he based an entire business on it. Millions of gun owners based their purchase of these braces on this letter from the ATF. Do you disagree with this letter that the ATF, when President Obama was president, that the ATF sent to Mr. Bosco?
Well, I can't comment on the 2012 letter, which I know nothing about, but the fact of the matter is the braces have changed over time. The ATF determined that gun owners were using a loophole. And so it's a different brace today than at the time that letter was written. And as I stated before, current owners of stabilizing braces can comply with the rule in the manners that I stated before.
Let me dispute something that you said. You said that the brace is different today. Does that mean if Mr. Bosco makes the exact identical brace that he sent to the ATF, he should be allowed to do that?
The brace from 2012, I would think so.
I would
but
think
obviously
so
the
too.
braces are not the same today.
But I'm glad you agree that if the ATF told him it was legal, that he should still be able to make these, as long as he adhered to the very same brace that he sent the ATF.
In 2012.
So he's given me, I would have brought it, but we're not allowed props in the Rules Committee, but he's given me this brace, the very same brace that he submitted. It was based on that prototype, and he's wondering why he can't make these anymore. And this just gets to the point that offends so many Americans, that the ATF said it was legal, and here we are a decade later, 40 million gun owners later, and the ATF now says it's illegal.
No,
and there's
a difference. The first brace that Mr. Bosco submitted was a forearm brace that he never brought to market. There's no change in the law for firearms with stabilizing braces that are not, quote, designed, made, and intended to be fired from the shoulder. A firearm, I should say, with a stabilizing brace that's designed, made, and intended to be fired from the forearm, which was Mr. Bosco's design back in 2012, is not subject to the NFA as a result of the rule. It's braces that are designed to be fired from the shoulder, that are designed to enable the pistol to be fired from the shoulder.
Well, it's not different. There are cosmetically different versions of it, but it functions exactly the same.
The fundamental difference is either if the brace is designed in such a way as to be a forearm brace, that's okay. But it's designed in such a way as to enable a short-barreled pistol to be to be fired from the shoulder, then that's subject to the rule.
Now you get into another legal distinction about how it's designed and how it's used. And the law does talk about if it's designed a certain way, and Mr. Bosco designed it not to be fired from the shoulder. And so you're applying two standards here. Was
No,
it designed to be fired from the shoulder, or did the consumers who bought it then fire it from the shoulder? You can't use both legal regimes to regulate this, but I am glad. Let me just ask you again. If the ATF told him something was legal 10 years ago, should he be able to make that?
Yes, but
Would the gentleman yield
remember
a question?
that the forearm brace is what was held to be legal by the ATF. The shoulder brace is what the ATF has objected to and what we're talking about today. And the ATF, exactly, after all, is the experts we deferred to on their judgment on these matters generally.
This, I mean, there are pictures. Here's a patent picture. It's a handgun brace. It's a forearm brace. It's not a shoulder stock.
Well,
And this is from 6 years ago, when the patent was issued or filed. So you're trying to have it both ways. You're talking about, is it designed a certain way? Was it the intent for it to be fired from the shoulder? But now you're implicating it because you say people use it for things it wasn't intended for. Let me get to an important point. This is so critical. You're saying they're not banned. That's just not correct. In 13 states, you can't own a short-barreled rifle. So the ATF's directive that if you don't want to destroy it, or that you can register it as a short-barrel rifle, does not hold true in 13 states, does not hold true for 36%.
but that's a state law. It's not a matter of federal regulation. That's a state law, as you just said.
But it was legal in that state until the ATF came up with this rule, and now you have, by using the state laws, banned these in 13 states, where 36% of the U.S. population resides.
Mr. Massie, states are permitted to ban things that the federal government doesn't. Happens all the time.
Okay, but it's a de facto ban because the state is relying on the federal definition, and you've changed the definition after 10 years of precedent, after written correspondence from the ATF. You've changed it, so you can't say that people can keep these if they want to just by merely registering them with the federal government because, as you're saying, the state law overrides the federal law.
In those states, you cannot.
You cannot, okay.
In those states.
Thank you for
Because
acknowledging that this is a ban in 13 states.
But this, we're not talking, not this bill, I'm sorry, not this rule that this bill would seek to overturn. The states, by law or by state regulation, can ban things that the federal government doesn't.
But on May 30th, they weren't banned in these states, and these state laws didn't ban these stabilizing braces, and on June 1st, they are banned in 13 states. What's so hard to understand? This is a ban. This is a de facto ban. Let me move on to something else. Mr. Nadler, Ranking Member Nadler, do you know what the punishment is for somebody now who's in violation of this rule?
No,
What the conviction would result in?
no, I do not.
What would be a fair prison term for owning a piece of plastic?
It's not, I'm not a judge, and I'm not going to say what a fair prison term would be. I'd have to look at other comparable crimes or comparable regulations and see what their prison terms are, or what their penalties are.
With all due respect, you were chairman of the Judiciary Committee,
Yes.
though, and there were some mandatory minimums that were
Well, I've
established.
always opposed mandatory minimums.
We can agree on that. But this, I think you might be shocked to know that millions of Americans are subject to, you want to take a guess how long they would serve for having this piece of plastic on a gun? Mr. Klein, do you want to comment?
I thank the gentleman that's up, it's up to
$250 fine, $250,000 fine, and up to 10 years in federal prison.
10 years in prison.
I would also point out that
Let me,
it's not the ownership of the accessory that triggers a penalty. It's the use without following the regulation.
it's the possession.
No, it is not the possession.
Well, if you possess one of these, it is the possession, it's not the use. And Mr. Klein is correct. I'll wait until you can pay attention. I know you're getting coached.
Thank the gentleman.
I was, sorry, Mr. Klein, I wasn't talking to you.
It's the possession of the accessory that attaches to the gun that makes it a short-barreled rifle. That is what is prohibited.
So now you agree with me, it's possession, not use?
No, it's the use, I'm sorry, I shouldn't say possession. It's the use of the brace with the short-barreled gun to make it in effect, a rifle.
I'm not a lawyer, and I've never been chairman of the Judiciary Committee, but I do know what possession is, and you don't have to use this brace if you merely possess it on a pistol that you are now a felon as of June 1st if you haven't registered this with the federal government or destroyed it.
It's possession of a short-barreled rifle, not of the brace.
And so you're agreeing it's not use?
No, I'm not agreeing. If you have the brace and you do not attach it to a short-barreled rifle, that's fine. But if you attach it to I shouldn't say a short-barreled rifle, a short-barreled gun, but if you attach it to a short-barreled gun, thus creating a banned weapon, that is prohibited, just like the possession of a machine gun is prohibited.
Okay, thanks. I'm glad we got the terms here now. Back to my question. Do you now know how long somebody can be convicted for?
Mr. Klein told us.
Yeah, do you remember what he said?
I think he said 5 years and $10,000.
10 years. 10 years for each infraction. If you own 30 of these, you could get 30 years. Or 3 of these, you could get 30 years. Does it seem a little extreme to get 10 years in prison for owning a piece of plastic that the ATF for 10 years maintained was legal?
Again, it is not for owning a piece of plastic. If you follow the proper procedures and you don't convert your pistol into a short-barreled rifle, which is prohibited, there's no crime.
It's for owning a piece of plastic that you've owned for up to 10 years.
It is not for ownership of the piece of plastic at all. You can own it for as long as you want. You can have as many such things as you want. It's use of it with a pistol to create a short-barreled rifle, which is what is prohibited.
So are you saying if you merely detach the brace from the firearm, you're no longer violating the law?
Yes.
Okay, that's what Mr. Dettelbach said too. But neither of you understand this rule because you will be convicted for this. The ATF slides, their documentation that accompanies this rule, it all says that you have to destroy the brace or make it otherwise unreattachable, that it can't be attached to the firearm. So you can't have this thing laying around. In fact, Mr. Jordan and I were so surprised that Mr. Dettelbach thought the same thing you do, that all you got to do is separate these things. In fact, can you find me his letter in this? Or his statements from Mr. Dettelbach said that all you have to do is separate the two. But the ATF rule doesn't say that. But you're saying that, Mr. Dettelbach says that. And what's the problem with your testimony and Mr. Dettelbach's testimony is Americans are watching this. The deadline, by the way, was June 1st. And the only thing that keeps those people from becoming felons since June 1st, well, I hope they live in one of 5 districts where the federal courts have ruled against this thing already, this abomination. Mr. Klein.
And I thank the gentleman for making that clarification that the grace period I spoke of that expired soon was exceptionally soon. It was 12 days ago. So I appreciate the gentleman for clarifying that.
The one right before that. Anyways, I had his letter here somewhere. Let me ask you, Mr. Nadler, let me ask you a question first.
Let me read you from the ATF website.
Okay, read us that.
Other compliance options provided under the final rule are the following. remove the short barrel and attach a 16-inch or longer rifled barrel to the firearm. Permanently remove and dispose of or alter the stabilizing brace such that it cannot be reattached. Turn the firearm into your local ATF office or destroy the firearm. The option to...
In addition to registering.
And of course, the option to register the firearm tax-free pursuant to ATF Final Rule 202R, 202TR 8F is in effect.
I'm glad you read that. So now do you understand why what you said before was inaccurate, that all you have to do is separate them?
Or,
Because here, let me read you what Mr. Dettelbach, this is the director of the ATF, said about this rule. Detachment, that's not for us to regulate. If somebody simply, we wrote the rule to make it easy to comply with. If somebody just at their home detaches the weapon from the brace and keeps them apart, they do not have to register anything. They can keep the brace, they can keep the business end of the gun.
correct.
That is incorrect. You just read me the rule. Like, this is why we shouldn't be letting the administrative branch write laws, because the people who are supposed to be writing these laws, which is us, and the ATF director don't even understand the rule. And these have consequences, if somebody violates this, of 10 years in prison. And unless there's been a federal injunction, which there have been, but not for the entire country, you could go to prison for 10 years for having one of these on your pistol.
On your pistol, yes.
And for 10 years, that wasn't the
Yes,
case.
on your, no,
and there's
on your pistol, because that's what this seeks to stop. You can have a brace, you can have a pistol, but you can't attach them to make it, in effect, a rifle,
let me ask you something. Isn't it,
which has been prohibited since 1934.
do you think you're going to stop any shootings by doing this?
Yes.
Which, can you think any of the mass public shootings or any of the shootings in the past, that the shooter would have said, oh my gosh, it's illegal to have this thing on this thing, and I'm going to go do a shooting?
All you can say is that if this regulation is in effect and enforced, it will make it harder for people to have mass shootings because the weapons will be less repeatable.
What do you mean by repeatable?
A repeat shooter, that is to say, semi-automatic in effect.
This brace has nothing to do with whether the firearm is manual bolt or semi-automatic or fully automatic.
It makes the pistol, which is otherwise inaccurate. I mean, any pistol is inaccurate, but when you can fire it from the shoulder, it becomes much more accurate.
So why wouldn't they just bring a rifle to the shooting, or two pistols or more rounds? Let me ask you a question. Isn't it true that you would prefer to ban all AR-15s?
Yes.
And isn't it true that you would prefer to ban anything with a detachable magazine?
I would prefer to, yes, to ban the magazines. Well, actually, to limit the magazines to 15 rounds. That was our legislation that we had last year.
And you think keeping them at 15 rounds instead of 16 rounds makes the firearm
Well, 15
safe?
rounds instead of 100 rounds. I mean, you have to set the limit somewhere.
Are you aware that you can just carry more magazines?
Yeah, but it takes time to reload. And gives law enforcement an opportunity to
I'm
shoot
sorry,
you
but
while you're reloading.
why did you pass a bill out of your committee to ban all AR-15s?
Yes, we did.
Why, were you here in 1994 when the so-called
Yes, I
assault
was.
weapons ban was passed?
Yes, I was. That was my first
Do
time.
you think that that was helpful?
Indeed, it was, until unfortunately it wasn't renewed in 2004.
Do you know that during the period of time, can you explain how it helped? Because here's what you need to know. In that period of time between 94 and 2004, the number of so-called assault weapons more than doubled in the United States. because the ban that you passed in 1994 was on the cosmetic features. And much like this rule from the ATF is on a cosmetic feature. So although it would have made criminals out of people who tried to sell something that looked cosmetically similar to what you banned in 1994, gun manufacturers just they just kept making AR-15s and AK-47 style weapons with different cosmetics. And so if you think it worked, I'd like to know how you think it worked, because the number of so-called assault weapons just ballooned from 94 to 2004.
I do not think that is the case, and I think you'll find the statistics are that the number of mass shootings went down from 1994 until 2004 and sharply increased after 2004.
So if they went down and the number of so-called assault weapons doubled during that period of time.
I don't think that's true.
But it is true. So let me ask you this. Why didn't Majority Leader Schumer bring up your gun legislation if this was such a priority for your party?
Because he didn't have the votes to overcome the filibuster, like a lot of our legislation. Take 60 votes in the Senate. Democrats didn't have 60 votes.
But it wasn't worth voting on?
I can't answer that. I don't know this Senate schedule. But he knew he didn't have the votes.
Did all the Democrats support it in the Senate?
As far as I know.
I heard there were some Democrat senators who thought that your legislation went too far.
I can't speak to that. I didn't speak to all the Democratic senators.
Let me just summarize here. You're the former chairman of Judiciary, still the ranking member. I respect you, to serve with you there on that committee. But I was surprised to know that you didn't realize people would get 10 years in prison for doing something after June 1st that they had done for 10 years prior that was authorized by the ATF for 10 years. I am concerned that these people can be prosecuted now as felons with, as Mr. Klein said, extreme monetary penalties and 10 years in prison. And a lot of these people don't even know that they're in violation of the law. The other thing I was surprised about is your interpretation and Mr. Dettelbach's interpretation of the rule is wrong. And if people were to follow his advice, which you repeated, which is to merely separate the two, they're still felons subject to 10 years in prison. But the good news is there are multiple federal court injunctions against this rule already. And I think what's going to sink it is the fact that the evidence that the ATF themselves for 10 years believed that attaching this accessory to your pistol did not make it a rifle.
As I said before, you were talking about apples and oranges. That was a forearm brace, not the shoulder brace.
And Mr. Bosco is going to be pleasantly surprised that he can continue to manufacture the firearm, except that he's not, because you're wrong on that too. This will ban, in fact, the very sample that he sent to the ATF that the letter was based on. That sample itself will get you 10 years in prison now that this rule is in effect. What the American people, whether they own one of these braces or not, I do not own one. I have some AR-15s. I do not own one of these braces. What they're offended by, whether they even own a gun or not, is this notion that you could be doing something legal. You could get the government's permission. You could get the government's authority to say that what you're doing is legal. And then one day you wake up and you're a felon.
It's not correct.
That is what's offensive. That's, to my colleague before me, that's why we need the REINS Act. We should be passing these laws. We never passed one here in the House to do this. I wonder why we didn't. I wonder why the Senate didn't do it. It's because the American people don't want it. It's being pushed on them from an administrative branch, from bureaucrats that aren't elected. You have no recourse. They do a notice, and then they take public comment, and they can ignore it, and they typically do. Part of the public comment they ignored here is the $250 million that they admit is the financial impact of this. This goes well beyond a regulation of, let's say, some level of emissions, this carries with it criminal penalties. I mean, I know that some people in here think that the administrative branch should be able to determine amounts of sulfur dioxide and things like that, and that we shouldn't be here. We'll let them tweak the knobs. But when they tweak the knobs so far on our laws that they create tens of millions of felons that can be punishable by 10 years, they've gone too far. And that's why we have support of Americans who don't even own one of these braces, may have never seen one of these braces. They don't care. They want a rule of law, not a rule of the executive branch. And that's why Mr. Clyde's Congressional Review Act invocation is so important, and that's why we need to throw this rule out. And I yield back.